Ready, start. While I accept the contention that the advertisement did not require the actual possession of property, the suitability of a candidate to provide for infrastructure could only come through an objective assessment of how such an affirmation is made by a candidate. Full stop. Inevitably, it has to depend on whether there was adequate proof adduced at the time of interview. Full stop. It must be noticed that the petitioner was not considered ineligible for being called for the interview. Full stop. Its affirmation that he could arrange infrastructure was sufficient to give the first reckoning for being called. Full stop. At the interview, if the corporation had decided to assign marks on definite proof offered through documentary evidence, I cannot say such an appraisal is arbitrary. Full stop. In this case, the third respondent produced before proof of his possession through a lease deed in respect of the property where the godown was proposed to be established. Full stop. If at the interview, the third respondent had been found as most suitable by the objective material placed before the interview committee, then, the higher marks assigned to the third respondent for the total reckoning cannot be faulted. Full stop. I cannot find fault with the interview committee looking for objective material for an assertion that he could arrange a property if, he would have been awarded the dealership. Full stop. Next stanza. The third respondent has also staged a march over the petitioner by the assessment of a relative better assessment obtained for the business acumen. Full stop. The counsel argued that the petitioner had been awarded only 3 marks for the business acumen, whereas, the third respondent had been awarded 7 marks, it shall not become possible for me to assess how the business ability of the third respondent was assessed better over the petitioner. Full stop. One interviewer has passed 2 marks to the third respondent, 1 marks to the petitioner. Another interviewer has awarded 1 mark to the petitioner and 2 marks to the third respondent, while yet another interviewer has awarded 3 marks to the petitioner and 1 mark to the third respondent. Full stop. Overall, the 3 interviewers have awarded more marks to the third substitute that judgment and enter into the realm of appraisal on a quality such as single quotes business acumen single quotes. Full stop. All the interviewers have assessed the third respondent higher than the petitioner in terms of the marks. Full stop. Next stanza. Even apart from the relative merits as assessed by the interview committee, there is one more reason why I think the petitioner cannot be preferred. Full stop. The third respondent brings evidence for the fact that subsequent to letter of intent and before filing of the writ petition, the third respondent had already invested about rupees 10 lakh for construction of the godown. Full stop. Photographs have been filed along with the reply. Full stop. The learned counsel states that the letter of intent was issued only on 5th July 2005 and the writ petition had been filed on 18th August 2005 itself and comma therefore there was no delay full stop. The counsel appearing for the third respondent comma however would argue that the results have been announced immediately after the interview was conducted and the petitioner did not file the writ petition till the letter of intent was issued to change the selection of the third respondent full stop over.